មួយចុះ
Please be seated. The court is now back in session. For the second item of the agenda, that is the determination of the scope of case 002/02, the second item on the agenda pertains to the determination of the scope of case 002/02. On 24 December 2013, the trial chamber requested that written submissions on this issue be filed by 31st January 2014. All parties filed their submissions on that date. The co-prosecutors reiterate their earlier proposal, arguing that case 002/02 should include the S21 Security Center, the treatment of Vietnamese, the treatment of the Cham, the Tram cooperatives, and Krang Tachan Security Center, including treatment of Buddhist and forced marriage. The first January dam work site, the Kampong Chnang Airport construction site, the O Konasai Security Center, and the Phnom Kraul Security Center. The lead co-lawyers concur with the crime size and events proposed by the co-prosecutors, but also request the inclusion of the Tropeng Thmo Dam work site, the North Zone Security Center, and Kok Kyong Security Center, Forced Transfer 3, and related East Zone purchase, as well as charges of forced marriage and factual allegations related to the treatment of Buddhists on a nationwide basis. The Nuon Chea defense team submits that Nuon Chea's principal interest is to have a full opportunity to adduce exculpatory evidence in support of his defense, and to that end propose the inclusion of the Tropeng Thmo Dam work site, either the Wat Kiri Room Security Center or Wat Lok Security Center, the alleged policy of internal purchase, and the alleged third phase population movement as the most important allegations. Finally, the Khieu Sampon defense team requests that case 002/02 cover all of the allegations in the closing order that were not addressed during case 002/01. The trial chamber will now hear oral arguments from each of the parties. These arguments should focus on responding to the submissions filed in writing and should not repeat the substance of the parties' own written submissions. The order of responses will be as follows. Nuon Chea's defense team's responses, 45 minutes. Khieu Sampon's defense team's responses, 45 minutes. Civil party lead co-lawyers' responses, 45 minutes. And co-prosecutors' responses, 45 minutes. The chamber would like now to give the floor to Nuon Chea's defense team to present their response. You may proceed.
Thank you, Mr. President, Your Honors. As we have explained in writing, we have no substantive position concerning the scope of the next trial. We acknowledge that the charges prosecuted in a criminal trial are not usually selected by the defendant. As Nguyen Chia's lawyers, our concern is only that Nguyen Chia is able to defend himself against whatever charges he does face. Our client's primary concern in that regard concerns the opportunity he will be given at trial to put forward exculpatory evidence in support of his defense. Nguyen Chia himself has explained on several occasions that he cannot defend himself if the chamber focuses on the body of the crocodile and fails to consider its head and its tail. For Nguyen Chia, defending himself means telling a story that goes far beyond the conditions in crime sites and formal structures described in the CPK statute. Relevant to Nguyen Chia's criminal liability is not only what happened, but why it happened, and who was responsible in a divided and chaotic revolutionary state. Relevant to our client's liability is not only who the CPK was fighting, but who was fighting the CPK. In the trial that we are about to start, it is imperative that Nguyen Chia has an opportunity to establish two critical facts. One critical fact is that the CPK faced a legitimate, serious, and ongoing security threat over the entire period of democratic Kampuchea. The second critical fact, Mr. President, is that the CPK was not a unified entity, but an association of competing factions linked by a complex web of alliances and oppositions. These facts are, of course, related. The security threat came primarily from foreign actors who supported opposition groups within the party in a war against the government. And some of those opposition groups ultimately triumphed. And the ones who did now lead the prosecution against Nguyen Chia. Now, Mr. President, none of these facts arise naturally from or relate to any one crime site. In order to prove these facts, we will require the flexibility to enter into evidence a wide range of material across the case 002 closing order and beyond. We should not be required to establish exactly in which sense every document, witness, and question pertains to the crime sites at issue. The Chamber must instead give us leeway to explore and investigate facts in support of Nguyen Chia's defense. This is an opportunity that was not provided to us during the investigation or undertaken on our behalf by the Office of the Co-Investigating Judges. Only if the Chamber decides that it will take a restrictive view of the evidence admissible in this second trial do we make any concrete request to include specific crime sites within the scope of case 02/02. If the Chamber limits us to matters narrowly relevant to the crime sites in case 02/02, as we feel it generally did in case 02/01, we must insist that the trial include the allegations in the closing order most closely linked to Nguyen Chia's defense. And in general, these include allegations in respect of crime sites based in the East, the Eastern Zone, and the Northwest Zone. We note and support the civil parties' request to include Traipang Tman Dam worksite, the alleged third phase population movement, and the alleged purge of East Zone cadres within the scope of the trial. And we have no objection to their further proposal to include forced marriage and the treatment of Buddhists. As we did in our written submission, Mr. President, we would also seek the inclusion of either the Wat Tlork or Wat Kirium Security Center, which are both crime sites in the Northwest Zone. Now, our only other comments about the scope of the trial concern S21. In our written submission, we expressed serious doubts that this chamber could impartially judge allegations concerning S21 and possibly any part of case 02/02 after its judgment in both case 01 and case 02/01. Now, we have spent much of the last 2 months reviewing this chamber's decision in case 001. And in nearly every paragraph, we find conclusions of fact we intend to dispute should S21 form part of the scope of case 02/02. And there seems to be no realistic possibility we will be able to persuade this chamber that the conclusions it formed after 17 months of proceedings were incorrect. Although, Mr. President, this is possibly premature, permit me to offer the chamber a preliminary glimpse of some of the findings in the case 001 judgment we find troubling and intend to dispute in any trial concerning Nguyen Chia's responsibility for S21. One general subject concerns the number of victims at S21, including both the number who were detained and the number who were executed. As you know, the Chamber relied exclusively for that purpose on the so-called revised S21 prisoner list, a document compiled by DC Chem and subsequently modified by the co-prosecutors. The case 001 judgment against Duik contains no analysis of this list of any kind and no effort to examine the underlying originals, let alone any discussion of the authenticity of those originals. Yet the only seemingly hard evidence of detainees at S21 in the form of photographs and confessions constitute less than half of the number on the revised S21 prisoners list, around 5,000. Newly found evidence, Mr. President, from Chinese sources refer to similar numbers of detainees. And these facts beg the question whether, contrary to this Chamber's finding beyond a reasonable doubt in the Duik judgment, the number of detainees at S21 might have been around 5,000 and not 12,272. Related is the Chamber's conclusion that every prisoner on the revised list, with the exception of one, was executed, and that therefore on that basis at least 12,272 people must have been killed. Interestingly, as you know, the one person the Chamber decided hadn't been killed was Chu Mei, one of the very few former detainees to appear before the Chamber in the Duik trial. And it's only because it seems the Chamber happened to know that Chu Mei was still alive today, or then, that it was able to conclude he did not die at S21. Yet the fact that Chu Mei's name was on the co-prosecutor's list never seemed to have prompted the Chamber to ask itself what would seem to be, in our view, an obvious question. If Chu Mei's name is on that list, number 1,583 of the prisoners supposedly detained and supposedly killed, but Chu Mei is alive, how do we know that everyone else on that list was indeed killed? In fact, Mr. President, we have already identified a number of detainees on the S21 prisoner list who were released. These are people whom this chamber has already ruled beyond a reasonable doubt died at S21. And this took us almost no effort. We did it in a matter of hours on the basis of publicly available information. We did it before we even started to prepare for cross-examination, let alone conduct the cross-examination itself. We also intend to dispute the Chamber's conclusion concerning the frequency with which torture was employed against detainees at S21. The Chamber concluded that interrogation techniques routinely employed violence and that threats were routinely put into practice. We intend to challenge the sufficiency of the evidence supporting these conclusions. The Chamber, for instance, also found in the Duik judgment that every single instance of detention at S21 was unlawful. And this is another finding we intend to contest if S21 is included as part of the case 02/02 trial. We raised once before the possibility that some of the conduct at S21 may have been lawful, that it might have been justified by military necessity. The co-prosecutors found that suggestion of that possibility, and I'm quoting them now from their previous severance argument, they found that morally repugnant. This is the kind of thing we on the defense, of course, are accustomed to. All we have to do is suggest that some of the conduct charged might not have been criminal, just that is apparently considered reprehensible. Now, Mr. President, this is the extent to which the presumption of guilt has taken hold in these proceedings. And in this kind of context, how can our client accept that a chamber, which has already found that conduct to be criminal, could reassess that question with an impartial mind? And our findings in the judgment go beyond S21. The case 001 judgment against Duik concludes, for instance, at paragraph 383, that intellectuals were executed in general because of their background as intellectuals. In paragraphs 99 through 101 of the judgment, the Chamber concluded that there was a policy of smashing enemies. Now, these are, as you know, conclusions we disputed in case 02/01, and we will continue to dispute them in a next case 02/02. Last example, with your permission, Mr. President, another holding in the case 001 judgment against Duik we may seek to dispute in the next case concerns the Chamber's findings in relation to the existence of an international armed conflict. In our view, there are many questions still outstanding concerning both the nature and period of the armed conflict. Did an international armed conflict truly exist prior to December 1977, as this chamber held in the Duik case? Was there sufficient conflict among CPK factions within the party to maybe constitute a non-international armed conflict at any point in democratic Kampuchea? Now, in our view, Mr. President, Your Honor, these are questions which deserve much more reflection and analysis than they received in the judgment against Duik. Obviously, Mr. President, an analysis of the substance of the evidence on S21 at this stage is very premature. But I point to these few examples to illustrate for the Chamber why we think the case 001 judgment against Duik is so troubling from the perspective of impartiality. Our client doubts that the Chamber, which made these complex conclusions, is able to judge him fairly, not only, but especially with regard to S21. For that reason, in our view, the case 001 judgment against Duik is reason enough to disqualify this Chamber from adjudicating Nguyen Chia's responsibility for S21. But even so, the case 001 judgment against Duik is only the beginning. This chamber will shortly issue a judgment in case 02/01. We do not know what that judgment will say. But many of the conclusions urged upon this chamber in case 02/01 about the structure of the CPK, Nuon Chia's role, and the supposed policies of democratic Kampuchea would directly impact this chamber's impartiality in case 02/02. The chamber has already concluded that at least 12,273 people were unlawfully detained, tortured, and killed at S21 without any real adversarial assessment of the evidence. Now, if this chamber enters the case 02/02 trial, having also already decided that Nuon Chea was responsible for military and security affairs, that the CPK functioned in an organized and strictly hierarchical manner, that the CPK had a so-called policy of summarily executing enemies, our question, Mr. President, is this. Insofar as S21 is concerned, what would be left to adjudicate in case 02/02? What line of defense would be available to Nuon Chea that this chamber has not already told him it disbelieves? Maybe it is a failure of our creativity, but we on the Nuon Chea defense team cannot think of one. The impartiality problem is also substantial in regard to the rest of the closing order. If the chamber convicts Nuon Chea for crimes charged in case 02/01, if it holds that he acted with criminal intent to harm hundreds of thousands of people, how can it be seen to approach Nuon Chea's criminal liability in case 2/2 in an impartial manner? Will the chamber really approach ambiguities in the evidence without any preconceptions about how Nuon Chea acted? Or will it approach them already having decided that our client is a monster? Will the chamber judge our client fairly? Or will it assume that he is the kind of person who must be guilty of the crimes charged? Mr. President, Your Honours, our final comment about S21 and about the scope issue more generally concerns the representativeness of the charges within the closing order and the Supreme Court Chamber's most recent decision on severance. As you know, we have previously made extensive submissions concerning the representativeness of the closing order. We argued that, contrary to the submissions of the co-prosecutors, S21 is not representative of the closing order in any respect. And we will not repeat those submissions which are familiar to the Chamber. We will only point out that the Supreme Court Chamber's decision on severance did not conduct a substantive analysis of representativeness. It replicated our position concerning the scope of case 02/01 and that of the co-prosecutors. But it never embarked on a thorough analysis to determine which charges would constitute a representative interpretation of the closing order. So, Mr. President, to us, the status of the Supreme Court Chamber's decision in that regard is not clear. Thank you.
The President, thank you. Mr. Sonaran, you may proceed. Counsel Sonaran. Mr. President, I do not have any observation. Thank you. The President, thank you. Now I hand over the floor to the defense team for Mr. Kiew Sampon. You may proceed. Good morning, Mr. President. Good morning, Your Honours, and good morning to all parties. Responding to the scope of case 002/02 on behalf of the defense team for Mr. Kyu Sampon. We observe that to date there have not been any agreement among the parties to the proceedings. The disagreement amongst the parties will lead to the delay of the proceedings. Particularly, it will likely amount to various appeals regarding this point. For example, the severance of case 002 into several segments is one of the consequences that we have received to date. Because we do not know the exact scope of case 002/01, not until the last stage of the proceeding. And now again, we are dealing with the uncertainty once again in case 002/02. If we look objectively at the possibility of the discussion that the trial chamber have convened thus far, we have spent substantial court time to deal with this issue. If all the facts and charges have not been severed from the beginning to date, we might be somewhere at the stage of the proceeding, but unfortunately we cannot return to the earlier stage because we have gone a long way until now. The severance of case 002/01 from the entire case 002 have amounted to the complicated procedures, and this will affect the interest of the my client, the accused, and it has also made the proceedings rather complicated for the chamber. I would like to respond to the observation by the prosecutors as well as the lead co-lawyers for the civil parties concerning the consequence of the undue delay of the proceedings, as well as the issue of financial trouble that this court might encounter due to the severance of the current case. In general, we are of the view that the issue of funding should not be the burden on the prosecution. It is entirely the burden of those who wanted this court in the first place. They have to ensure that this court can function smoothly. And we are of the strong view that this court should not be held hostage of the funding availability of this court. If this court does not have sufficient funding in order to ensure that the justice is found, this court may not be able to meet its mandate, and eventually Mr. Kyu Sampon has to be released. This is the foundation of justice, because justice is not dependent on the availability of funds. I do not want to address on any particular fact or particular charge that the defense team for Mr. Kyu Sampon is seeking the trial chamber to include in the scope of case 002/02 for the following reasons. In order to ensure that it is easy to examine the entire case file, as well as in the interest of the defense of my client, and to ensure the smooth proceeding, the defense team for Mr. Kyu Sampon requests the chamber that all facts and charges are examined. The charges that have been brought forward by the prosecutors, the charges that have remained from case 002/01. We believe that doing so will not add any complication once we have to discuss on the scope of case 002, because people have been wondering as to how broad the case 002/02 will be, and whether there will be any case 002/03. If we can include everything in this segment of trial, we will be able to conclude the entire case. We will be able to deal with all the remaining facts and charges left after case 002/01. Another important thing that allows this chamber to examine all the charges and facts left from case 002/01 will enable Mr. Kyu Sampon to exercise his right to his own defense effectively. I would like to bring up the one of the decision of the trial chamber, document E302/5, paragraph 5. I would like to read it out for the chamber. The trial chamber wishes to reminds the party that the severance of the proceeding, quote, is purely the means of the proceeding for the only purpose to ensure the order of the charges indicated in the closing order, and that those charges are subject for the examination and adjudication. In this particular section of the decision, it is very clear that the chamber points out that it is a pure means of proceedings, and the chamber is of the view that this means of severance serve that purpose, but to us it is not the case. There have been a lot of concerns raised by the parties, and particularly on the health status of the accused, as well as the frailty of the accused condition. And these facts have induced this court to sever the current case. This is one of the important fundamentals that I believe that everyone who is present in this court will agree. Now, assuming that the current accused were at 30 or 40 years of age, would there be a severance at all? So I believe that the severance of the current case was meant to convict the accused before they die. That is the facts before us. And that particular intention may not allow Mr. Kilsampon to exercise his right to his defense effectively. That's why on behalf of Mr. Kilsampon, we earnestly request the Chamber to examine the various facts and charges left from case 002/01. Thank you, Mr. President. The President, thank you. And Council Vakang, you may proceed.
Yes, thank you, Mr. President. Very briefly speaking, I would like to add to what my colleague just developed a comment. And this comment focuses on the attempt of the prosecution to address the issue of representativeness, the representativeness of the trial. And I imagine that this temptation will be even greater as the Chamber has told us on 7 February that this is not, we're not speaking about distinct cases, 00201 and 00202. It's still the same case. And especially owing to the recent decision of the Supreme Court, which again concludes in some kind of contextual analysis, concludes that, finally speaking, the solution should be to the difficulties we are facing, since the Chamber is not immediately ready to include S21 in the first trial, might be possibly to take everything that the parties are requesting to include in the first trial in order to define the second trial. This is how the Supreme Court seems to be proposing to pick in the requests of the Nguyen Chia team, from the civil parties and from the prosecution, everything that is requested to be included in the first trial in order to define a second trial, which, globally speaking, would provide this characteristic, together with the first trial, of proper representativeness. I do not want to proceed in this way. Maybe it's a very clear way of thinking on the part of the Supreme Court, but I don't want this to be used to counter our request, and that you decide that you defined the second case as having to include everything that remains. And it is for this reason that I began my submission this morning with the issue of Kilsampon's health. And the Supreme Court has said to us in its decision, which is of course imperfect, but no one is perfect, the trial chamber, and this is in paragraph 65 of its decision, the Supreme Court is telling us that the trial chamber committed an error of law when it rejected the criteria of reasonable representativeness as not being applicable to the case at hand. And then comes this rather surprising analysis of the possibility of restricting the number of charges. I don't exactly understand what the Supreme Court means here by restricting the number of charges. And finally, what's stated is that it is possible to define the second trial, which taken together with the first trial will offer proper representativeness of the case. Of course, why not? But at the same time, the Supreme Court is telling us, again here, the criteria for representativeness only comes into play as of the moment when we consider that the defendants or that que son parent is too old or that he is about to die or that he is ill. And I repeat again, this is not the case. A little while ago, who would have banked on the fact that we would still be discussing the scope of a second trial in the presence not only of que son parent, but even of Mr. Nunchia? This issue of representativeness is, of course, useful, but for Mr. que son parent, and in the case of Mr. que son parent, nothing allows us to say today that he will not be able to survive until the end of the following trials, no matter the way you will define these subsequent trials, as maybe the way that we're requesting, because this seems to be the least worst of the cases, that is to say, a second case that would encompass the totality of the charges that remain in the indictment, or as you may define it, as I interpret it in your recent decisions, you will maybe define or issue a new severance, and maybe later on down the line create a third trial. But in any case, nothing allows us to say that Mr. que son parent will not be around until the end. And the Supreme Court has studied in depth in its recent decision this question, and it understands that when a severance is decided, the pros and cons have to be weighed in properly, and the consequences have to be considered for an accused person who is in good health, for an accused person who probably will not pass away tomorrow. The consequences of a severance order, which the Supreme Court tells us will in fact postpone or delay the trial instead of speeding it up. So, the most reasonable proposal that we were able to find, and we regret the decision that your chamber took on 7 February on the general admission of evidence from the first trial into the second trial. And we would like to remind you that the Supreme Court, in its recent decision in paragraph 39, stated, using the example, and stated that evidence should be used in the second trial, and I quote paragraph 39, regarding the role and the authority of the accused, the evidence should be examined in each trial. This is what seems to be the Supreme Court's position regarding this matter. So, to be perfectly honest, and even if this will not prevent us from using all legal means that will allow us to defend properly Mr. que son parent, we believe, nonetheless, that the most expeditious solution, the most efficient solution, the most logical solution would be to not try to use a criteria of representativeness that seems completely inappropriate here. There are no elements that allow us to substantiate it or to consider it as valid. And to try the case based on all of the remaining charges in the indictment. I even thought that this could be a solution, or a possible solution could be to drop the charges that you do not want us to discuss today. But of course, this can be considered in a French court in which the prosecution has the responsibility to call witnesses before the trial chamber. But here it is the chamber that decides on the evidence that will be tendered. So this solution of dropping the charges is not something that I propose because it doesn't seem to correspond to the rules governing your chamber. Maybe I'm not entirely clear for all of you, but I'm sure Judge Laverne understands. No matter what, today, the solution that is the simplest would consist in trying what remains in the indictment and to stop issuing severances, especially since the following cases have not yet been defined, and when we are trying defendants who have been detained for more than 6 years.
The President, thank you. The time is now appropriate for lunch adjournment. The chamber will adjourn now and resume at 1:30 this afternoon. Security guards are instructed to bring Mr. Kyew Sompon to the holding cell downstairs and have him return to this courtroom before 1:30. The court is now adjourned.
សូមអញ្ជើញក្រោកឈរ